Welcome to Inside Report. I'm your host, Matthew Miano. With me today is one of the most prominent former U.S. attorneys in Washington, D.C., who really has his finger on the pulse of what's going on with the Mueller probe, with President Trump, everything that's happening in the city. Joe DiGenova, thank you so much for joining us today.
My pleasure.
So I want to open with the House Judiciary Committee voting to hold Attorney General Barr in contempt for not producing an unredacted version of the Mueller report. You wrote in a recent op-ed that Barr refused to do so because it would be illegal for him to do so. Can you describe to our viewers what's going on?
Well, this is a kabuki fake dance by the House Judiciary Democrats. They know full well that the Attorney General cannot disclose grand jury information which composes part of the report. In addition, he has made available to them the entire report on a come and read it basis and has even expanded the universe of people that can come and read it with minimal redactions. The notion that he would be in contempt for refusing to produce the unredacted report to the Judiciary Committee is ridiculous. And I have no doubt that that is why, if they in fact take it to the House floor and hold him in contempt, they will not refer it to the United States Attorney's Office under the statute, which they are allowed to do, because no U.S. attorney is going to prosecute that ridiculous case. They may try to go to court and get a civil decision to enforce the subpoena. I think they're going to lose that, and they're going to be rebuked by the federal court for wasting its time. And then the third alternative for them is to use what is called their inherent power of contempt, to hold him in contempt on the House floor, and then seek to fine him, they say. I don't think they have the authority to fine anybody, absent a specific statute, or jail him somewhere in the House of Representatives. I would only say this to the House. If they try to jail the Attorney General and send the House Sergeant at Arms, I wouldn't want to get involved in a gunfight with the U.S. Marshals who protect the Attorney General. This is quite a silly exercise. It's an embarrassment to the House, but the Dems have no shame, and so it's pretty tough to embarrass them.
Now, Congressman Nadler said that we are in a constitutional crisis because of this contempt vote that they undertook. Is he correct?
Well, that again is also nonsense. There is no constitutional crisis. They've issued a subpoena. He has indicated that he has produced all that the law allows him to produce. That's not a crisis, that's a comedy. And the House Judiciary Committee has created a comedy of itself. They look like something out of a very bad movie. It's probably would be called Mr. Smith Leaves Washington rather than Comes to Washington after watching these idiots on the Hill. This is really quite embarrassing what they're doing.
Some have compared the contempt charge to that of Obama's former Attorney General Eric Holder over the Fast and Furious scandal. Do you think there is a comparison there?
Oh, none whatsoever. In the Fast and Furious case, the Obama administration, the Attorney General, and the President Obama, refused to produce key documents in the scandal which involved the illegal transfer of weapons to cartel members in Mexico by ATF, the Alcohol, Tobacco, and Firearms part of the Treasury Department. They refused to turn over documents. The litigation went on for 2 years, and they still haven't produced all the documents in that. That was an entirely different situation. That was a complete stonewall. They produced nothing and then eventually produced limited numbers of documents. They claimed executive privilege on tons of documents. He wasn't held in contempt for the executive privilege documents, but for the ones that were just never produced. In this case, Attorney General Barr has produced almost the entire report except for the grand jury material and made it available, the parts that should not be made public except for grand jury, to the members to view in a private setting. So I don't know how you can find any of that contemptuous.
And in the Fast and Furious case, that was a case where people actually died.
Yes, there was an agent, a border agent named Brian Terry, who was murdered by Mexican cartel people with one of the weapons which had been diverted purposely by the Department of Justice to the Mexican cartel. And they lied about that for a number of years until eventually the documents leaked out that showed that Agent Terry had been murdered by cartel members using one of the guns that Eric Holder had allowed to be diverted.
So that's a tremendous difference between murder and someone who can't legally release information.
You can't be in contempt of Congress if the law prohibits you from producing the document that they want to see. So this is going to be a very quick proceeding if it ends up in court. I just think they're probably going to do something pretty stupid and try to handle it in the chamber itself and then try to fine him and seek to enforce that. They're certainly not going to lock him up. I mean, if they were to do that, I think there would be, I don't know how they would do it physically. I don't know how you arrest the Attorney General by the Sergeant at Arms of the House. Pretty ugly.
So there's a practical issue with that.
Well, yeah, I just don't know how they're going to arrest the Attorney General. I mean, if they hide out in his bushes at his house, they're not going to get that close because the marshals guard him 24 hours a day.
What do you make of the legislative branch just issuing subpoenas left and right?
What you have here is, because of, now remember, even before the Mueller report had been issued, Jerry Nadler sent 81 letters to 81 different individuals and institutions to produce documents. There is no precedent for the shotgun approach to the issuance of demand letters and then subpoenas. There are at least 3 subpoenas in the House issuing subpoenas to the administration. This is clearly an effort, an abusive, vindictive effort by the House of Representative committees to embarrass the president, to waste his time, to intrude on the proper functions of the executive branch, going after his taxes, for example. There's no law that says a president has to produce his taxes in order to run for president. He didn't. He was elected president. The Democrats don't like that, and now they're making an issue out of this. They've said they want to see his returns so they can judge whether or not the audits of all presidents, which are required by law, are being conducted properly. And yet they haven't subpoenaed the income tax records of any other president. So this is clearly a pretextual subpoena. It's done to hector the president, to badger him, to embarrass him, and to make it a political issue. They're going to lose that. Now, that doesn't mean that a lower judge isn't going to say you can have them, but they're going to lose in the Supreme Court because that's where all of these subpoena issues are going all the way up. The administration is going to litigate them all the way to the Supreme Court. This is a fishing expedition in every sense of the word. It is vindictive, it is abusive, and most importantly, under U.S. Supreme Court law, there is no valid legislative purpose. In the absence of that, these subpoenas are all dead on arrival.
Let's talk about the Mueller report for a moment. Can you address this obstruction issue surrounding Trump that all of his detractors seem to be sounding the alarms on? Because it seems that the Russia collusion has taken a major back seat here.
Well, Mr. Mueller concluded that there was no evidence, not some evidence or insufficient evidence, but no evidence of a conspiracy or a coordination between the Trump campaign, Trump himself, and the Russian government. So once that was settled, that left the Democrats with the so-called obstruction theory. Mr. Mueller refused to charge the president with obstruction. He said he didn't exonerate him, which is not his job as a prosecutor, but he didn't want to charge him, and he laid out all this evidence. The memo itself, the Mueller report, is 400 pages of violations of the constitutional rights of the president, his privacy, Department of Justice guidelines. Mr. Barr could have rightly refused to release any of it, but he didn't think that would be in the interest of the president or the Department of Justice or the public. And it's pretty clear that Mr. Mueller, mostly Mr. Weissman, Andrew Weissman, who was his lead investigator, wrote this in a manner to embarrass the President of the United States, not to make any legal points, because in a traditional non-prosecution, or what they call a declination memo, where you decline to prosecute, which is what this was, you simply write a summary paragraph explaining that there was insufficient evidence. That's not what they did here. They smeared the president for 400 pages. Even in the collusion, conspiracy, coordination area, they didn't have to write all that. They could have concluded there was nothing. No, they wrote 200 pages of nonsensical, idiotic material that was designed to embarrass the president. They did the same thing on the obstruction issue, And I must say, I think Mr. Mueller embarrassed himself terribly. I think he placed the Department of Justice in a very, very bad situation. And I really hope he testifies, because I can't wait to see what people like Jim Jordan or John Ratcliffe are going to do to him on cross-examination. When did you conclude, Mr. Mueller, that there was no collusion, conspiracy, or coordination? When did you tell Mr. Rosenstein that? When did you tell the Attorney General that? I mean, this was an outrage, what Mueller did, and he has really harmed his reputation. Not with the mainstream media people who view him as a demigod, but among people who are right-thinking and care about the interest of good government. He's been a disgrace, and his reputation has suffered greatly from this.
You and your wife, Victoria, wrote an op-ed that after the Mueller report was published, people like John Brennan actually doubled down on Russia collusion to the point of, well, there were inappropriate conversations, so this probe was necessary. Is that a basis for prosecution?
Well, first of all, Mr. Brennan is the primogenitor of this entire plot. All of this started with him insisting that there be an investigation by the FBI into Mr. Trump and his campaign, with no evidence whatsoever. Brennan, enlisted the services of foreign intelligence services to assist in planting evidence that would find its way to the FBI and eventually into applications for Foreign Intelligence Surveillance Act electronic warrants. Mr. Brennan has become a bit of a nutcase. You can watch him on television. He is insistent. He's belligerent. He really acts like a very guilty man, protesting a bit too much about just about everything. The truth is that any good lawyer looking at these facts could have told you that there was no basis not only for a criminal prosecution, but there was no basis whatsoever for a counterintelligence investigation. There was no proper predicate. There were no facts to sustain a counterintelligence investigation. And the facts that did exist were made up by the U.S. intelligence community, fed to the FBI through foreign sources, and then used to obtain FISA warrants. This is a great scandal, and I think Attorney General Bill Barr is going to get to the bottom of it. And the only way you can do that is with federal grand juries, and I expect those to come soon.
So you mentioned FISA. Mm-hmm. Judicial Watch uncovered the FISA applications to spy on Carter Page and, in effect, the Trump campaign. You and Victoria also wrote that our intelligence tools were basically used against political opponents, in this case, Donald Trump and others. Can you please walk us through what exactly happened?
Sure. When it was determined that they needed to stop Trump from becoming president, you have seen the Strzok, Page, McCabe text messages and all that. They had to stop him. They had to prevent him. She had to be president. He was horrible. He couldn't win. He smelled like the people at Walmart, et cetera, et cetera, et cetera. And so what they did, they constructed a story out of whole cloth in order to get FISA warrants on Carter Page. And they clearly framed George Papadopoulos by sending people to give him false information that he would eventually feed back to other people, other foreign intelligence services, which of course he didn't do. The foreign intelligence services basically made up what Papadopoulos told them. In fact, the Australian ambassador has denied that he said what it's been reported that George Papadopoulos told him. As a result of all of that, the FBI used newspaper articles which had been generated by Christopher Steele, the foreign spy who was hired by the DNC and Hillary Clinton and Fusion GPS, to put together information on Trump, none of which was true, none of which was ever verified, creating the Steele dossier. And Andrew McCabe has testified that but for the Steele dossier, there are no warrants against Carter Page. Now, it's my understanding from my conversations with people that the Inspector General, Michael Horowitz, who is investigating the FISA warrants and the possible abuse, has determined that the 3 extensions of the original warrant were all illegal, that they were based on bad information. They are now focusing on the first application for the first warrant in October of 2016 on Carter Page. And they were working on getting to a conclusion when it was discovered in the last week, some very fine reporting by John Solomon of The Hill, that made a major memorandum concerning Christopher Steele had been hidden by the FBI from the Inspector General. That memorandum was written by a Deputy Assistant Secretary of State who said, after meeting with her staff with Christopher Steele, who came in to see them, that he was basically a liar, unreliable, that he had a bias against the president and his campaign, that he wanted to hurt the president, that he helped Hillary Clinton, and that he wanted to get this information out before the election. This woman, the Deputy Assistant Secretary, her name was Kavalek, wrote a memo to the FBI and sent it to them immediately within 24 hours. The FBI, we now know, received it and did nothing about it. They buried it. They never told the FISA court, because remember, they had this information before the first application for a Carter Page FISA warrant. They never told the court about that. They never in any way undercut the credibility of Christopher Steele. And as a result of that, all of this other stuff was used to create a false investigation about the president. And the proof is in the pudding. Even Mueller, who was completely co-opted and anti-Trump, had to conclude that there was no evidence of a conspiracy with the Russians. So what you end up with is a false investigation, lies created by the intelligence community, by John Brennan, fortified by Comey's cooperation on it, knowing full well, he said in his testimony, that the dossier was salacious and unverified. Doesn't sound like it was the kind of information you should be given a federal court, but they did it anyway.
And to underscore that, just to underscore the seriousness of the situation, no hearings were held for these applications. Were you surprised to hear that?
It's quite normal for FISA applications to be decided on the paperwork. And the reason is, since the act was put into existence in 1977, the care with which the department has prepared the applications has been really excruciating and very professional until the Obama administration. They would frequently go to the judges and give them a sample of what they were seeking and be told this isn't going to make it. And so they would never even apply. They would do a test. In this particular case, they simply lied to the court. This was Sally Yates, the Deputy Attorney General, John Carlin, the Assistant Attorney General for the National Security Division, McCabe, and others at the FBI who prepared these documents. James Baker, the General Counsel, says he stands by every word in those applications. God bless him. Maybe he doesn't have any choice, because that's going to be his defense. He acted in good faith. The bottom line is they lied to the court, and they've disgraced the FBI and the Department of Justice, and the senior officials at the Department of Justice under Obama, Sally Yates, Loretta Lynch, John Carlin, all the people in the counterintelligence section have disgraced themselves, and they've harmed the department very, very much in the FBI. It's going to take, in order to solve this problem and have accountability and get the dignity and respect back for the institutions of DOJ and FBI, there's going to have to be a grand jury.
So we have Mueller, Strzok, Page, Comey, Brennan, all these, and Weissman, as you said earlier, all these cast of characters that were involved in the targeting of then candidate Donald Trump and even now President Trump.
Yes.
Do you think these people will be held accountable?
Well, the only way they are going to be held accountable, other than by public embarrassment, which I'm all for, by the way, is at least one federal grand jury, probably two, one in D.C., one in Eastern District of Virginia, to pull all of them in and force them to testify before a grand jury, or maybe they'll take the fifth and they won't. But you cannot get full accountability without the power of subpoena and the grand jury. That's how this is going to be settled. Bill Barr is a very serious Attorney General. I'm quite sure that he will not be in any way diverted as a result of this ridiculous criticism of him by threats of impeachment or contempt or whatever. He's going to go forward. It's going to be investigated. And Mr. Brennan and Mr. Clapper are going to have an opportunity to do that. But I want to make one point that's very important for your viewers. People have to understand that this scandal has actually been wide open for everybody to see since April 26, 2017. That's when Chief Judge Collier of the FISA Court issued a 99-page opinion in which she outlined 4 years of illegal spying by FBI contractors who sought access to what are called the 702 databases. These are the databases about Americans. You can go in there if you're properly authorized and make what are called about inquiries. You want to find out something about this American citizen. They did that illegally for 4 years, and it is believed that those 4 years of obtaining that information illegally led to various unmaskings of people who should not have been unmasked, American citizens, and then the leaking of that information to the press. That is a scandal that as yet has gone unnoticed by the media and unpunished. And the hero in that story is Admiral Mike Rogers, who was the head of the National Security Agency at the time, discovered this, notified the FISA court, and for his heroic efforts, Ash Carter and John Clapper tried to get him fired. So that's the great story. Admiral Rogers is the hero, and all the lawyers are the crooks. We do know that the White House was made aware of all of this counterintelligence activity, that President Obama was aware of it. We know that from Susan Rice's memos to the electronic file. But this is Brennan's baby. This is Brennan's Rosemary's baby. This is his Rosemary's baby. John Brennan started this. He hated Trump, and he used the powerful tools of the United States intelligence community to weaponize intelligence. He also may have done something else that people haven't talked about. The 1947 National Security Act makes it illegal for the CIA to spy in the United States or to cause people to spy in the United States. John Brennan did that in this situation when he started this entire scheme. And I think he should be held accountable for that, and I hope he will be.
Joe, you're one of the few people that are sounding all the alarms on everything that's going on with the corruption at the DOJ and FBI under the prior administration, even some holdovers into the current administration. Thank you so much for joining us today and filling our viewers in on what's going on.
My pleasure. Delighted to do it.
Thank you so much for joining Inside Report. If you enjoyed this video, please be sure to subscribe to our YouTube channel, like us on Facebook, follow us on Twitter, and follow us on Instagram for all the latest updates. Thank you, and we'll see you next time.